everybody. I see a lot of familiar faces. I see a lot of names and no faces, but um, really excited to have you all here for this first Ambassadors of Law Students, Lawyers in the Constitution series. Um, I was going to start out by acknowledging and thanking Dean Fiona Hall, who's been my partner and co-collaborator in developing the Ambassador series. So Dina is at least is right in the center of the screen here, and next to, I mean Fiona is, excuse me, is next to me, and we see the Ambassador Series as an opportunity for our law students and our faculty and other friends of our various law schools to meet and discuss with faculty members rule of law issues and constitutional law issues and issues that have underpinnings in the value of our democracy and the importance of these topics to members in of our community. And we see our law students as ambassadors of law. And so, what we hope you will get out of this series, and certainly out of tonight's presentation, is some basic information about the particular issue that we're discussing, and that you might share it with your friends and family and community members, because people will come to you as law students, future lawyers, and ask questions. What does this mean? What is birthright citizenship all about? What's going on? What's the Supreme Court really looking at? And we want to provide that information for you in a way that's understandable and balanced and offer a perspective. So I want to thank Fiona again because this process was created with collaboration, our collaboration, and help with some other faculty members in putting this together. I want to thank Dina Dowsett for handling the strategy and the media and really making this event possible and really working hard and putting things together to give you materials and an opportunity for you to be here tonight. I see our president over in my right-hand corner, Lisa Spiro, and obviously I know you have a mission not only of, high standards in educating law students, but I know that you're very well connected in the community, and our law students are part of these communities. And we see this program as part of the mission of all of our law schools. And lastly, I want to introduce Professor Christopher Kurowski, who is my colleague tonight. And I've had an opportunity to work with him over the last several weeks, which I've really enjoyed. He's a truly talented law professor and lawyer. He's a graduate of Berkeley Law. He's been practicing immigration law for over 30 years. He has a long resume. I will not summarize all of it for you, but I will tell you that he has served at some pretty high levels in the immigration arena. He has been involved in Human Rights Commission. He served as honorary counsel for the Republic of Poland out of San Francisco in terms of the Polish consulate. He's a super lawyer in Northern California for 15 years, and he's a very interesting lawyer to talk to about these issues. So I'm really honored that he is here tonight, and that's one last piece, and then we're just going to jump into this program. I want to share with you is that we have 150 faculty members. Lisa, I'm not sure, 130, something like that, adjunct faculty members. And we think that it's an interesting experiment to use these webinars for all of you to meet law professors from different campuses, from different backgrounds, and to bring that pool of talent together. And I see Professor Wagner over here in the corner as well, who's been doing this for a long time. So Stephen's very nice to see you, Mickey Welsh, Kathy Stoner, some of our faculty. This is great. It's great to have you here. Let's jump into tonight's topic, Born in the USA, New Challenges to Birthright Citizenship. I want to start out, I found a short summary of the topic from the Brennan Center, the Brennan Justice Center, and I want to just read it to you. It's short, but it kind of frames the issues. And then Christopher and I are going to get into a conversation about some of the issues facing the United States Supreme Court. I do want to point out that oral argument on the birthright citizenship case, President Trump's executive order 14160, will be held on April 1st, which is this Wednesday, before the High Court. And so you can just Google, Supreme Court oral argument um, in Trump versus Barbara or Barbara versus Trump, and you can actually listen to the arguments. And after our discussion today, I think you'll be, poised and primed to really understand where the lawyers are going and where the questions are directed to them from members of the court. And hopefully, it will enhance the experience. And I invite all of you, if you can find some time, it's recorded, listen to it at night if you want. It's going to be a fascinating argument. So, what does President Trump's executive order do? What it purports to do is to deny citizenship to any baby born in the United States to a mother who is present unlawfully or lawfully but temporarily, and a father who is not a United States citizen or a lawful permanent resident. That's what the order does. In other words, under this order, U.S. born children of undocumented immigrants and the children of parents residing in this country under temporary legal authorization, such as student visas and work visas, will not be considered United States citizens. Now, the order directs federal departments and agencies to, quote, deny documents recognizing U.S. citizenship to these children. Well, the order doesn't really explain what that means, but it does mention the Secretary of State and the Commissioner of Social Security. And what that means is that children would be prevented from receiving passports and Social Security numbers, among other documents. The children would still presumably get birth certificates because those are issued by, state and local governments, but those certificates would no longer be considered proof of U.S. citizenship. So that's kind of a framework from the Brennan Justice Center. Um, Christopher, why don't we just sort of jump into it? Let me turn to you, and if you can, maybe frame for us what's the United States Supreme Court being asked to decide in this case, and talk a little bit about the 14th Amendment and the federal statute that covers birthright citizenship.
Thank you, Joel. Before I answer, I'd just like to thank Dean Hall, Dina, and yourself for allowing me to do this. I'm a big supporter of and a fan of Empire and Monterey. Been teaching for 6 years now, and I want to say that I currently have two current staff members as students there and two that were former staff members. So a number of alumni as well. And one of my associates I met in my classroom. At one point, I had hired three of my students after they finished my class. So not to plug my immigration law class, but it's worked out well for Michael Villafana, my associate, and for us, of course. Anyway, I know all of you might not have time in your lives, school lives, to fit in immigration law. That's why I think this kind of program is wonderful, because it'll give you a little taste of some of the issues involved, and I hope we can do more of these. I'm very passionate about immigration law, so if any of you are interested and can find the time, I'd love to have you in my future classes. So to answer Joel's question, the case is going to turn on basically three things. One, the definition or meaning of the 14th Amendment, and particularly the clause related to birthright citizenship. The almost identical language of the statute that was passed in 1952. It's the Immigration and Naturalization Act of 1952, 8 USC 1401A. And then I would say the precedents involve primarily, or let's say most importantly, the U.S. Supreme Court precedent decision of Wong Ark, which, at least the respondents are claiming is directly on point. So to get to the crux of it, both the statute and the 14th Amendment have language that basically says all persons born in the United States and subject to the jurisdiction thereof are citizens of the U.S. The language is almost identical for both the amendment and the statute. So the question is, what does that mean? And the Trump administration, in support of its executive order, is arguing that the phrase all persons born in the US is modified by the phrase uh, subject to the jurisdiction thereof. And that is a significant modification in that it does not include children of people here that are undocumented or here on temporary visas. The people challenging the law, which we'll call the respondents, are claiming that that interpretation doesn't hold water, that basically the case of the Wong case, as well as 150 years of precedent and practice, have held that, in fact, if you're here and you were, whether you were a citizen or a lawful permanent resident or had no status at all, your child born here becomes a U.S. citizen. And so that's the crux of it, is what does that phrase mean? And, how will the Supreme Court rule on this? And as we'll talk about in a minute, there are significant consequences for our immigrant community.
Can I interrupt you just with just a point or a question? Is the Trump administration's argument essentially is focusing on the status, if you will, of the parent, the process, the person who gives birth to the child, what is her status, as opposed to the baby itself, which had been
Correct.
historically the focus. In other words, the creative argument or the new argument that's being advanced is you have to look at not protecting the child or recognizing the child, but looking first as to whether or not the status of the parents are legal or illegal. I mean, making a sort of a shorthand observation. And this is an argument that's never really been advanced in the past 150 years or whatever we're looking at. Is that a fair statement?
Yeah, and I would also point out, though, that there has been efforts to pass legislation
Right.
to take away birthright citizenship. Almost every year in Congress, legislation like this is submitted, is introduced, but it's never come close to being approved, going back to 1995. So it has been an issue. It's just never been seriously considered by a court or Congress. Now, if you want, I could sort of specify how the Trump administration is trying to make this argument and what the response is. I mean, basically, the Trump Solicitor General, Trump administration Solicitor General, is attempting to parse the language so that the language born in the U.S. has to be limited by the phrase subject to the jurisdiction thereof. And then that basically turns on whether they are not just subject to our laws, like everybody here, but rather have some sort of political jurisdiction, meaning sort of political allegiance, meaning their parents are citizens or lawful permanent residents, as opposed to somebody here who's undocumented. Their argument being that if you're undocumented, let's say from Mexico, you're really a citizen of Mexico, and therefore your political allegiance and jurisdiction is with the government of Mexico, and therefore your children should be that way too, and that therefore they're not covered by the 14th Amendment. That's essentially their argument. And so they're attempting to separate out people who are here legally and their children, including citizens, but also permanent residents, from those people who are here either illegally or temporarily. So legally, but temporarily here, which is a very problematic distinction, as we can discuss in a minute. So temporary visitors, or those unlawfully here, would have their children deprived of citizenship and basically be deprived of all status, absent some corollary legislation. It's not only that these people would lose their citizenship, they would lose any right to be here and would be subject to immediate deportation, presumably.
Would there be circumstances where someone might be here going through the process of immigration, but the child that's born would not have that protection, and therefore you can have a situation where theoretically a newborn could be deported while one or both of the parents might still remain in this country under,
Absolutely.
un,
That's one of the absurd potential consequences of this. Now, that could be addressed by legislation in Congress, but let me give you an example, okay?
yeah.
Because I have a pretty high volume practice. I've seen about 15,000 undocumented families in the last 10 to 15 years. So I see a lot of people, and many of them would be directly affected by this. So, for example, we do a lot of asylum cases. So you could have a situation where somebody comes here on a tourist visa. So they have one status to begin with. Then they become undocumented because their tourist visa expires. They're now in a different status. Then they file an asylum application and they're legally allowed to be here in this country while their asylum application is pending. That sometimes lasts 10 to 15 years. Then, if they are granted asylum, they now have a different legal status, but it's not permanent residence. So anyone in those four categories who would have children during those time periods, those children would not have citizenship, would not have automatically any kind of status under our current laws, and would be subject to immediate deportation. So you'd have the kind of absurd situation where the parents who have an asylum claim that might be pending for 15 years can stay, and they came illegally to the United States, right? Uh, but their children who were born in the US are subject to immediate deportation. Now, then
And you could have a,
afterward, go ahead.
and you can have a situation where once they gain status, they might have another child, and so one child might end up being a U.S. citizen while the other child's been deported, theoretically, right?
Correct.
Because once they obtain a certain permanent residence or some sort of, and one of the problems I have with these cases is they use the word domicile, which I think is a very loosey-goosey kind of concept that the Trump lawyers have been arguing in the briefs about being domiciled, because they get that from the Wong Kim Ark case, which addresses that. But you could have a situation where in a family where you have multiple births over a period of years, where some of the kids, some of the children are subject to deportation, and some can stay in the United States.
Absolutely. And you could have some families who had children born before this executive order that were undocumented. Those children would be US citizens if it's not retroactive. And now they have new children born after the executive order, and those children would be without any status and subject to immediate deportation, even though both children were born in the US. So it's very, especially if it's retroactive, but not only, this executive order could kind of wreak havoc on immigrant families on a way that would really may not be intended by it.
Let me ask you this. Do you think the Supreme Court may want to avoid the constitutional question, the challenge to the 14th Amendment, and instead, you know, kick this to Congress under the 1401A, which is essentially a congressional enactment that was adopted in 1952, which mirrors the citizenship clause. It has some additional features to it, but do you think that may be an off-ramp for the court to avoid sort of the complexities and the hardships that you've been addressing?
Well, I don't know if it will address it would address those hardships if it finds that the law passed in 1952 um, does provide for birthright citizenship for anybody born here. Um, if it Because that would obviously find that the executive order is contrary to law and therefore not prevent or present all those absurd situations that I just mentioned within immigrant families. I think it is a very nice off ramp and one they may choose to take because it will allow them to avoid a contradiction between their position and the Trump administration's position on what the 14th Amendment means. So they wouldn't be addressing that at all. They could say, we don't have to address it because the statute covers this issue. And they could conveniently say, the statute is different than the 14th Amendment, potentially, the meaning of it, because it was passed after 150 years of precedent, when at a time when it was well accepted, at least Congress thought it was well accepted, that if you were born here, you were a US citizen. So that would mean we're not saying the Constitution protects this. We're only saying that Congress chose to protect it in 1952. And that would also invite the Trump administration, and if it could get the support in Congress it would need, to pass new legislation that would basically preempt the 1952 law and make take away birthright citizenship by statute. So it would have a couple of nice consequences for what most people consider a conservative court.
Do you want to talk about retroactivity, or do you have any other thoughts that you want to, I know that the Wong Kim Ark case is a big part of this, and I don't know if you have any thoughts on to share with the students and faculty on that case, because I think, the Supreme Court theoretically could overrule that case, or if it read it, I think, thoughtfully, it could follow it as well.
Yeah, I think it's worth a few minutes of our time, and then we can talk about some of the issues raised by retroactivity. Um, so as many of you know, in the late 19th century, there was an effort to restrict Chinese immigration, and that's where this case came out of. There was also a number of laws, primarily the Chinese Exclusion Act of 1882, which severely restricted Chinese immigration. By the way, the congressman who authored that law was from Santa Rosa. Just a little bit of local history. Um, so at that point, the US government was trying to restrict Chinese immigration. They were looking for a test case to take on birthright citizenship, and they chose this instance with a 24-year-old immigrant, not immigrant, he's a child of immigrants, Wong Kim Ark, who was born in the US, but child of Chinese immigrants who were legally in the US, but did not have citizenship and had apparently no way to get it. Now, to make a long story short, the customs official involved refused to let Wong Kim Ark back into the country, ordered him deported. He then mounted a challenge impressively while detained on a series of steamships off the coast of San Francisco. There were various community organizations in Chinatown, San Francisco, that did some amazing legal work challenging some of these Chinese exclusion laws, and they were the ones who took this on. It went all the way to the Supreme Court, and they got a favorable ruling from the majority. It was a 6-2 split, and the majority held basically they adopted the same arguments that the respondents in this case are promoting, which is that, hey, the 14th Amendment covers this, and it specifically says if you're born here, you are a U.S. citizen. And the minority, basically, there were two justices who promoted the views that are almost identical to what the Trump administration is promoting. So what the Trump Solicitor General is trying to do is distinguish the Wong R. Kim case by saying, hey, that case involved a child born of people legally in the US. And the executive order addresses children born of people illegally in the US or people with temporarily legal residence. So I'm sorry, I meant to say they were permanent legal residents in the Wong R. Kim case. In the executive order says if you have permanent residence here, then your child has birthright citizenship. But if it's temporary residence, or you don't have any status, then your children do not get birthright citizenship. So they're trying to distinguish the two cases, and essentially.
What's confusing to me is they use the word domicile. they don't use sort of, permanent residence or that seems to be the anchor of their argument. And that word is, it seems to me, is vague, and it's different than residence, and it seems to be kind of a difficult concept um, to work with, even though the Wong Kim Ark case used the word domicile in it.
Yeah, it doesn't have any meaning in immigration law.
Right.
It is confusing. But essentially what they're saying is you have to have permanent residence or citizenship to have your child born here be given citizenship at birth. Um, Now, this retroactivity issue, I'd like to address that because it has a lot of interesting implications. Now, now what I mean by retroactivity is whether or not the law, which was um, basically uh, promulgated by the Trump administration in January 2025, whether that's retroactive to births before that date. Um, it purports not to be. So the actual executive order says this only applies to children born 30 days after the effective the effective date of the law. And so it draws sort of an artificial line as to when, who's covered and who's not. The problem with that, as has been raised by one of the amicus curiae briefs submitted by 200 congressional representatives to the Supreme Court, is that it's contrary to common sense and to law. If you think about it, it's the president does not have the power to determine whether something whether a constitutional amendment means something as of today, but not something different before. And likewise with legislation, they don't have the power to do that. The 14th Amendment either means this or it means that. It either means that children born of undocumented parents, for example, in the US are citizens, and it means that now, and it meant that before the executive order, or it means that they are not US citizens, but now and before. It can't be changed by edict of the Trump administration. So it's a very powerful point. And the problem is that if it is retroactive, it would wreak havoc on literally millions of families that are here in the US. And that's sort of a nice segue into talking about, who this law would impact and what that impact would be for our immigrant community. There's some numbers that we put in the materials that are available to all of you, and I recommend you look at them. But basically, roughly 225,000 to 250,000 children per year are born in the US to mothers who are here without status. So that's roughly 250,000 children per year. And it's about 5 to 7% of all the births in the United States. And so they estimate there's about 4.4 million US born children here who have at least one parent that are undocumented. And in fact, most children of undocumented families are US born rather than being born outside the US. So whether or not it's retroactive, if this law is ratified by the Supreme Court, is allowed to stand, it would create the disparities that we mentioned, where some children born before the act would be citizens, some born after would not, and some members of the same family would have status, others would not. But also, if there was, in fact, retroactivity, which, as I said, there's a big argument to be made that it must be retroactive if the Supreme Court upholds the Trump law, then you run into the problem that there are millions and millions of people living in the US who believe they have citizenship, over the last, 30, 50 years potentially, who were born here, but whose parents were undocumented. And those people now would suddenly lose their status retroactively. And it's really hard to calculate exactly how many people this would be, but it would be well into the millions for sure. And some of these people, have achieved great status in our country. Many of them have very impressive careers here. It's sort of analogous to DACA. If DACA was done away with tomorrow, there'd be doctors and lawyers and engineers and many others across the spectrum of jobs in this country, professions in this country who would be subject to deportation immediately. It would be even much more so in this case if this law is allowed to stand and is made retroactive. And furthermore, many of them have sponsored their spouses because it's very, very common in my experience for children born here. Sometimes they're often raised in Mexico, but they were born here. So they move back to the United States, they have US citizenship, and they bring their spouse from Mexico. They bring their children from Mexico. Maybe they fall in love with somebody in or some other country. It doesn't have to be Mexico, but they bring their child or spouse from that country. Now suddenly, do all those people lose their status? So you could see that this would be a super complicated, messy set of circumstances if the law is found to be retroactive.
Do you think the decision in the recent decision not upholding the tariffs that had been imposed by the Trump administration, in other words, setting aside the legality of that act, is a potential analogy here? In other words, um, to not allow the executive to sort of impose something that is, beyond the scope of the executive's power, and instead, again, allow Congress to. I mean, I think what the Supreme Court did in that case was invite Congress to, authorize these tariffs or to create a mechanism where Congress would approve the imposition of these tariffs. Um, they gave the president all kinds of alternatives to essentially and do you think the Supreme Court might be configured to do something similar here? Again, using the federal statute as I call it, as an off-ramp or maybe a middle ground to say to Congress, look, if you're that, here's a complicated problem. All these issues are in play. We don't need to address the constitutionality of the 14th Amendment citizenship provision. We're going to let Congress decide if it chooses to pass a federal statute which specifically addresses this and makes certain allocations and analyzes these complexities.
Yeah, absolutely. I think you called it an off-ramp earlier, Joel, and I believe it would be a convenient one, at least for the, let's say, middle block of the court. It's obvious that the Supreme Court doesn't act um, necessarily as a block. You have factions. You're going to have three votes almost certainly from the Democratic appointed justices that would argue this should be struck down. You're probably going to have a couple votes on the other side upholding the law. And so the decision, I would guess, will turn on the justices in the middle to the extent, yeah. So
Yeah,
they
to the extent you can find those, you're not sure who's. I mean,
Yeah, it's
it could
arguable who they are, but
be
whatever. There
Robertson,
are
Barrett,
there are some that arguably are in the middle, and those justices, could very well choose this off ramp, as you put it, because it will allow them to not contradict the the interpretation of the 14th Amendment that's obviously very important to Donald Trump, his administration, his many of his supporters, that is anathema to them that birthright citizenship is incorporated in the Constitution. So they wouldn't necessarily have to disagree with that, but they would punt the constitutional issue and then decide it narrowly on the statutory grounds. And as you say, in that way, almost invite the Congress to take action if they wanted to take away birthright citizenship by statute, just as they did to some degree in the decision on tariffs.
Lots of moving parts here, and obviously, some serious tension in terms of sort of constitutional analysis. Um, Let me see if there's anything else kind of on my list. Is there anything else, Christopher, that you want to,
Yeah, I just want to
you know,
go back to the point that we made in the beginning. A lot of the opinions, the arguments that have been made, and some of the literature that we've looked at and has been cited in our materials, deals in this in a lofty sort of way. Should children born here have citizenship? And if we take away birthright citizenship, you know, they no longer have a permanent right to stay in the US. But you have to remember, I think it's important to remember something that may not be apparent, which is once you take away that citizenship from a child born in the US, they do not have any right to stay here. There's no law that gives them any right to be in the United States one day once they are deprived of citizenship. So it's not only that they can't vote, they can't get a social security number, they can't work legally, and frankly, they're subject to immediate deportation. So you could have an absurd kind of ghastly outcome where, the Department of Homeland Security accesses birth records and basically takes into detention small children born of undocumented immigrants and deports them. Now, would that happen? Hopefully not, but there would be nothing in our laws to prevent it because that child would not have any status in the US. And the further absurdity is if their parents had come illegally but had some form of legal status other than permanent residence, like an asylum application, a U visa, VAWA. There's a whole bunch of things that they could allow them to live here legally, but have their children deported, even though they came illegally and their child was born here. So you could have some really absurd outcomes if this is applied. So we'll see.
yeah, I want to just point out a couple other, sort of legal observations, and then we can take some questions, I think. I don't know Dina, how we doing on time? You tell me
Good. You have probably you got about 6 minutes before opening the floor.
okay. Let me just mention a couple things. Um, this is a court that, really kind of looks at law from sort of an originalist point of view. You've heard we talk about this, whether what the reading the text and trying to understand what the framers intended. And I want to point out if the framers had meant to reject this kind of or impose a permanent residency or a domicile requirement on the citizenship clause, they could have done that because, for example, in Article 2, Section 1, Clause 5, on the requirements for presidency, they imposed a residency requirement for presidential eligibility. You have to live in the United States for 14 years. So way back when they were thinking about like what are the requirements for becoming a president, the founders and the drafters put in a residency requirement. Okay, that's not present in the citizenship clause. They know how to say it, they know how to draft it, they know how to require it. They did not do that. There are lots of cases protecting the rights of children born to, for example, even enemy combatants. During World War II, during the Japanese internment, children born to parents who were interned during World War II, essentially in concentration camps, as enemies of this country, were recognized as United States citizens. So there's a long history of a sort of law and policy that is staring in front of this United States Supreme Court, and that's precisely the kinds of factors typically the more conservative justices rely on to uphold, a particular position. So one of the things that is of interest to me in these oral arguments this week is to see, you know, what kind of distance, if any, the members of this court create from the history of this country for 150 plus years, where birthright citizenship has been recognized in so many cases and so many levels. To simply wholesale reject that concept, I think is going to be a heavy lift for the court. Um,
Yeah,
and
there's that one of the things cited in one of the arguments I read is that Chief Justice John Roberts wrote in a decision in 2024 that every statute's meaning is fixed at the time of the enactment. Every statute's meaning is fixed at the time of enactment. What he means by that is that, whatever the original meaning of the 14th Amendment was, you know, a statute that's passed in 1952, it has to be interpreted in light of what the law status of the law was and precedent was at the time that law was passed. And there'd been 150 years of precedent that children born in the U.S. were U.S. citizens. And as you said, Congress could have worded it differently and excluded people born of parents that were undocumented or here temporarily, but they didn't. And so it is a big climb to argue that the 1952 Act should not be interpreted in light of all the legislative reports, the judicial decisions, and executive practice that had preceded that for at least 100 years, if not more. So, yeah, that will be interesting to see. If I had to guess, I would not be surprised. I would probably guess that will be the way the court goes, is maybe to invalidate the law, but not on constitutional grounds, rather on statutory grounds.
okay, we want to take some questions. I,
Yeah,
I
I
don't,
could just jump in one of
yeah,
these.
just jump in.
Yeah, real easily. Anna asked, could the Supreme Court divide the order, say that it applies to children of illegal immigrants, but does not apply to children of parents with legal temporary status? Yes, I mean, anything's possible. So it to me, it isn't necessarily logical that you would make a distinction between children born of people with legal permanent status and children born of people with legal temporary status, especially since one moves to be the other very, very frequently in the United States. Usually you are in legal temporary status before you become in legal permanent status. So making that distinction is arguably hard to understand, especially because you'd have a lot of families, as I said, who'd have some children born as citizens and some children born not. You'd also have children who are subject to deportation, even though their parents are not, even though their parents came illegally here. So one way to solve some of those problems would be to adopt the distinction you're making and say, and draw an artificial or draw a line, let's say, that the Trump order doesn't, between those here illegally and those here legally, even if it's temporary. Now there's a point here about there's a very onerous law, very punitive law. Probably the worst immigrant crime you can commit is to assert a false claim to citizenship. So this is a law that says if I go and vote, even though I'm not a citizen, or even if I just apply for a job or certainly try to get in the United States claiming I'm a U.S. citizen, show a driver's license that's not mine that says I was born here, or a birth certificate, that not only makes me undocumented, but basically undocumented forever with very little exceptions. So basically it becomes a bar to a green card. So the question here is, would these children, now adults, potentially be subject to a false claim for citizenship bar from ever getting status because they thought they were citizens and did things like voting and getting U.S. passports? That would be even more absurd, of course. but it is something to keep in mind that these people's lives would be turned upside down if they were retroactively told in their adulthood that they were no longer citizens, even though they've been operating as such for, sometimes decades. There's another question. Do you anticipate respondents to argue that subject to the jurisdiction is synonymous, the phrase subject to the jurisdiction is synonymous with subject to the laws? What is your take regarding primary allegiance and how that will be interpreted? Well, we alluded to this a little bit. I think that what the respondents, meaning the people challenging the law, are saying is that, look, there really isn't any principal difference between the two. If I'm here and I have to obey our laws, then I'm subject to the jurisdiction of the United States. And, so that is sort of the fundamental kind of argument at the base of its interpretation of the language in the 14th Amendment and the statute. The government obviously is trying to make a distinction between those two. Everybody's subject to the laws, but if you're not documented, then you're not subject to the jurisdiction, nor are your children. So that is the difference. And yes, respondents are arguing that they mean essentially the same thing. The second part of your question is, what is your take regarding primary allegiance and how that will be interpreted? Well, it's a thorny subject. So what the questioner is alluding to here is the argument that the Trump administration is asserting that somehow if you are a citizen of Mexico and you're not a citizen of the United States and you're not a permanent resident of the United States, your primary allegiance is to Mexico and your allegiance is to Mexico, and therefore, you're not subject to the jurisdiction of the United States. It really has a lot of let's say problematic aspects. For example, a lot of people have dual citizenship. You can have dual citizenship in the United States. You can be a U.S. citizen and a Mexican citizen. Millions of people do. So are they then who's their primary allegiance to? Arguably they would not be covered by the executive order because they have U.S. citizenship. But how do you draw that distinction when they were first a Mexican citizen or a citizen of another country? So it's a tough argument to win.
Yeah, and I think in that question, Stephen, they would have to take the position that whatever the illegal or the improper allegiance that the parents may have or be imputed to them are inheritable. In other words, a child born of undocumented immigrants who have not followed the laws of the United States, arguably, has inherited, almost genetically, no allegiance to the United States is kind of the argument they would have to make. And I think that they're going to have to come clean at oral argument and talk about political allegiance, not just following the laws. I think there's another level that the Solicitor General's arguing based on some, sporadic quotes in history and some law review articles. I mean, it's mostly secondary authority. It's not major. There are no cases on this, but I think that they're looking for a political allegiance concept, a kind of an American allegiance idea. And they're going to impute that to a newborn. They're going to say a newborn inherits if you will, the illegal acts of, its mother and father. I don't know if that argument is going to come up, but I think that's kind of what the the underlying premise is, and we'll see if there's
Yeah.
any questions about that. I don't know whether you agree with that, Christopher, but I think that's what is at stake here is a redefinition of allegiance to the United States.
Right, and it's really becomes thorny in drawing those lines between somebody here who's a citizen, somebody who's a permanent resident, somebody who's a legal temporary resident, and somebody who's undocumented. I mean, anyway, it's a tough one in my opinion. There's another question here. Looking at the issue from an originalist standpoint, is there any historical reference or discussion made during the Fourth Amendment debates that would support tying birthright citizenship to a parent's residency or allegiance, or does the historical record really cut against that? I don't know of any. I don't know of any. I think that, in other words, I don't know of any support for the idea that the drafters of the 14th Amendment intended to limit that language in that way. In fact, there is some authority that preceded the 14th Amendment, which was 1868. So preceded 1868 for the concept that children born in the country are citizens. It was the English common law, and there's a great deal of discussion about that in the materials. So there was an English common law tradition, and that common law tradition rather continued in the U.S. prior to the 14th Amendment. There's a case that I believe is in our materials from Slate magazine. It's referenced in Slate magazine. There's an article from Slate about it.
Right.
I,
Yeah, Lynch versus Clark is the case. It's an 1844 case out of New York. It's a really
that,
interesting case.
yeah, very interesting case, which cuts against the Trump order because it involved people that were here illegally, and it was way before the 14th Amendment. Now it was only a state court case, but still it's indicative of the kind of precedents that were out there at the time the 14th Amendment was adopted, and certainly at the time the 1952 statute was adopted.
Yeah, the court used the phrase, they upheld the U.S. citizenship of a child born, quote, of alien parents during their temporary sojourn, close quote. In other words, they were here temporarily, they were sort of passing through. And there is some discussion in the respondents' briefs. I didn't get a chance to, there's a lot of briefs, like amicus briefs, but the respondents do cite some debate about this issue and when the amendment was passed, and it seems to me that this issue was addressed, and the idea of either temporary, presence in the United States or sort of passing through the United States and still giving birth in the United States would protect birthright citizenship. So there are some sites in the brief, pretty extensive sites that support some discussion of this during the time the amendment was drafted, and some debate. Um, uh, you know, and I think even in the 52 statute, if I recall correctly, there was some discussion of this as well in the ledge history there on this issue. Mickey, you ask a question up front, and do you want to turn your speaker on and clarify that? I'm not sure. I mean, I think it's Wong Kim Ark is really what they're using. They're trying to distinguish that case to say that was a case that really required an intent for permanent residence. They were calling it domicile, but what they were saying is since his parents were lawful permanent residents, essentially, that he was born here, he can get the protection of birthright citizenship. But if you don't have that status, you're not protected. So I don't know that they even want that case overruled. I think what they want is interpreted in a way that favors their view of what one needs to have in order to get protection for birthright citizenship. That is some kind of lawful permanent residence, some kind of, you know, permanent domicile in the United States. So I don't know if that answers your question, but that case is going to be the center, I think, of a lot of the oral argument on Wednesday.
Well, it seems to me that would be dicta in a case that only dealt with permanent residents, that it wouldn't say anything much about what happens with unlawful residents or temporary residents.
That's definitely the position of the Trump administration. Yeah.
Yeah, the court doesn't really hang its hat on that. There's a lot of language in the case that's very useful to the respondents. It's mentioned sort of foundationally, but it's not part of the sort of rationale of the decision. The court doesn't say we're using this as a condition in order to justify granting birthright citizenship. It's not linked. They just mentioned that they were domiciled in San Francisco or wherever in California. So, I mean, we're going to have to see what the court does with that case.
So, Professor Franklin, we are closing in on the end of the session. If you want to just have some closing words, and we will end it so our students can get to class.
Well, I'm really so impressed and so excited that you're all here with us having this discussion tonight. What we do as lawyers and what you do as law students, and we have administration deans here, other law professors here, is really important in this time in our history. We're a small group of individuals on a small screen with lots of little boxes and names after it, but really what we are ambassadors of the legal system, of knowledge of the law, of history, of how our democracy works. As I mentioned, we talked about this idea of an informed electorate. And Jefferson and Madison really believed that if our citizens were informed and had knowledge and understood how things worked, that if things go south or there are difficulties in our society, that they can right those wrongs. And I think we as a legal community, all of our law schools and our online students, all of our faculty and administration, are members of the community and serve that community. And I hope that this first session, and I want to thank, Christopher, Professor Karofsky for his, knowledge and clarity and involvement here tonight. Really was a wonderful session. And thank you, Dina and Fiona, of course, for the work on this. And we're going to plan more of these. And if you, as students, if you can sort of, if this is something that is valuable to you and you think you want to do more of this, and maybe we can grow this, we can actually get out in the community and do some speaking and some engaging. I like to see that happen as well. So thank you all for being here, and we look forward to the next session.